Okay.
All right, thank you. I'll turn it over to Tanya.
All right. Thank you. Can everyone see the slideshow? Yes? Okay. All right. One of the things that Benita talked about as I was preparing the slides and we were talking about the presentation is how do you make the procedural safeguards friendly and accessible for parents? And I have to tell you, going through it myself and preparing the slides, it is just, it's complicated. There's a lot of information. One of my goals is to try to pare it down and make it understandable and chunk it for everyone so that you can get a better grasp of what your rights are, what your child's rights are, and how you can better advocate for your child during the entire process, including IEP meetings and evaluations. There's a slide, a little bit about myself and some of the background information that we shared at the beginning of the presentation. You can please feel free to share the information that I'm providing today. If the only thing that you're not permitted to do is modify the information. So otherwise, share away. Okay. The IDEA and Section 504 both have procedural safeguards where the district is required to inform the parent of their rights and their children's rights. And I apologize for those little yellow lines. I don't know how they got up there. The procedural safeguards notice is, sorry. So what the statute said is the parent is to get a notice containing the full explanation of the procedural safeguards available under the IDEA and the Department of Education regulations. And so what happens when you go to these meetings when the district is required to provide you the procedural safeguards notice? And I was trying to find a way to have this book slammed down in the middle of the screen, because that's exactly what it feels like. You get a document. It's about 20 to 30 pages long. Sometimes it's double-sided. It's in small print, and it is just overwhelming. And what do you do? A lot of it, it is supposed to be in more friendly language. A lot of it really follows the language of the statute, and I think that's one of the difficulties. It's one of the difficulties that I had myself in going through. Trying to parse it down and make it more friendly and accessible, but fundamentally, the procedural safeguards, there are a lot of them, a lot of information in them, and we're going to try to get through that. Okay, when is a parent required to receive it? So the point of the procedural safeguards is to make sure the parent is not in the dark about your child's education. You're trying to navigate through this process, especially if it's your first child with a disability and you're going through the special education process. You have no idea what your child's rights are, timelines, what the district is supposed to do, who is supposed to be at a meeting, and there's just a lot of information. And what the purpose of the procedural safeguards is to give the parents a written notice of all your rights. So you're required to get them during certain times, certain key points in which you're interacting with the school district. So you have to get them at least once a year. You also get them when the initial parental request for an evaluation and consent for special education services. If you file a first state complaint, we're going to go through that a little bit later. You're supposed to get the procedural safeguards then. When you file your due process complaint, you have to get it then also. If there are any disciplinary actions taken against your child that rise to the level of an exclusion from school, and we're going to get to that also. These are significant things that occur during your child's experience at school. You're supposed to get a procedural safeguards then. And anytime that the parent asks for it, the district is required to provide it for you. So the procedural safeguards has to be written in a language that's understandable to the general public. Well, we can't check off that box ever. I think it's going to be very difficult. Hopefully you can check it off a little bit after this presentation. It's supposed to be provided in the parent's native language. So if your language is other than English, the Pennsylvania Department of Education has procedural safeguards notices in different languages. They are translated. If the school district is not giving you a copy in your native language, ask them for it. It should be accessible in your native language so you can go through it and understand it. There are some languages that are not common and not readily accessible. So there is an exception within the statute. If it's not feasible to provide you this notice in your native language, then they have to try to communicate your rights in a different way.
Tanya, question for you. Who's responsible to give you a copy of the procedural safeguards in your native language? Would that be the school district? Would that come from Pennsylvania Department of Ed?
It would come from the school district or the charter school or the cyber charter school, you know, the public entity, the IU that's working with your child. They're the ones that are required to give you procedural safeguards notices. So whoever's handing you a procedural safeguards notice in other than your native language, that's the person who's responsible for providing you that notice in your native language. If it's not possible to provide you the notice in your native language, then it can be translated orally. If the parent is not, you know, cannot access written language, they do need to make it accessible to the parent. It's very, very important that the parent is aware and knows how to access these educations so that you're aware of your child's rights. Okay, so I have broken down the procedural safeguards into different sections, and I think this may be a good way of just chunking it, compartmentalizing different parts of the procedural safeguards notice. And if any parent just wants to read a little bit at a time, you can, I would recommend trying to become generally aware of what's in there. For instance, there's information about when your child gets disciplined, you have rights. If, you know, there's a private school tuition situation happening, you have rights, you know, they're in there. So one of the reasons I made this slide is just to make you aware of what is in here. But you don't have to read all of it all the time. If, you know, your child is not in a disciplinary situation, you don't need to read that part of it. If your child is getting evaluated and, you know, the district is asking you for consent, you know, then I would recommend you read those parts of it just to make yourself aware. Maybe once a year, you know, add another section, and slowly you will start getting used to the way it's written and the information that it has. So evaluations. We're going to go through parental consent and independent educational evaluations. So who is a parent under the IDEA? So a parent can be a biological parent, an adoptive parent, but it's also the IDEA also includes people who can step into these shoes, and you do not need a court order to be able to step into some of these shoes. It's just a circumstances. The idea is that the child's educational rights should not be delayed because, you know, the parent or adoptive parent cannot make it to a meeting. You know, I mean, there's so many circumstances that occur in people's lives and your own family unit. Sometimes the parent is not able to attend a meeting or, you know, to be, you know, part of that. So, a foster parent is also considered a parent and can provide parental consent. any guardian who acts as a parent or is authorized to make decisions. So this could be a grandparent, a step parent, a relative, the aunt that lives down the street, because everyone in the family all lives on the same street. They all can step into these shoes if the parent is agreeable to it, and if the district is aware that that individual is stepping in the shoes of a parent. The school district can also agree to recognize someone as a surrogate parent when no parent can be identified, if the parent cannot be located, which happens sometimes, if the child is a ward of the state or the child is an unaccompanied homeless youth. So again, the idea is that education is so important that it has to be delivered to the student. And if the parent or adoptive parent, biological parent is not available, they do try to still get into a situation where they can deliver evaluations, special education services. When does a parent have to provide informed consent? And there are certain situations where the school district, or I'm going to call it the LEA, I called it the LEA in the slides because, again, it could be a school district, a charter school, a cyber charter school, it could be the IU. It's a public agency that is providing your child's educational services. So when the initial evaluation to see if your child qualifies for special education services, absolutely, the district cannot perform an initial evaluation or reevaluations really without informed parental consent. And that means not only to get your consent, but tell you what they're planning to do, what types of assessments are they going to use, what are they looking for, and what are they going to do with the information that they receive. And all of that is in the form, the parental consent form. So so you can read the little boxes on the form that they'll check off the reason for the evaluation. Before the first time if your child qualifies for special education services, and it's the first time they're being offered special education services in an IEP or an early intervention IEP, the LEA is not allowed to provide the services until the parent consents to them. So that is it's very special in the law, and it's the only time with respect to IEPs that the school district needs like an active consent from the parent. Otherwise, they don't do anything. After the initial provision of services, after your first IEP or your early intervention IEP, if the school district wants to make any changes, and we'll get into this a little later, they don't need your active consent to do it. There are different rules apply, but before they begin delivering services, they do need the parent's consent. If the parent does not give consent, they're not permitted to provide services. If they want to provide services, they can go to a due process hearing and ask the hearing officer for permission to do it. Okay, the parental consent, again, with native language. Again, this is the parent has to be informed. They have to understand what's happening. So these forms are also available in other languages. So if your native language is not English, ask for this form in your native language. They should have it. And the LEA has to make reasonable efforts to obtain consent. So it's not good enough to just put it in your child's backpack. And especially, with a child who loses things or, is very young and might fall out of the backpack, they might, say, well, we put it in the backpack or we threw it in the mail and you never answered. And that, too bad. The LEA has to make reasonable efforts, and they have to and document these efforts. So they have to try more than once. And if putting it in the mail didn't work, they have to do it a different way. They can drop it off at your house. If giving it to your child doesn't work, they could send it by certified mail. They do have to make an effort to engage the parent. Sometimes things get lost between, when it leaves the school district building and before it gets to your house. So, so they do have to document these efforts. Okay. You're not required to provide consent, so just because a district gives you something doesn't mean you have to say, okay. Typically, and I always recommend to parents, if you're looking for special education services and your child is struggling in school, please provide consent, because there are a lot of services that are available to students and that could make education and learning easier, kind of an easier road. But the law recognizes that, as a parent, you don't have to provide consent, but there are also things that occur if you don't. So, and you can also revoke your consent, which I typically don't recommend either. I think it's better to work with the process, and we'll talk about that as the presentation goes on. I'm sorry. I have little check marks. Okay, I'm gonna start moving faster. Okay. If no parental consent is provided for a request for evaluations or reevaluations, the school district or LEA doesn't have to do anything. They can't do anything because you haven't provided consent. They can ask permission through mediation or due process. I have 15 years of doing special ed. I haven't seen any district do that. But haven't represented everyone. So evaluations for kids in homeschool or private schools funded by the parents, the agency may seek that permission also through mediation and due process if the parent doesn't give consent. The initial provision of special education services, though, the first IEP, if the parent does not consent to receive those services, the statute actually says that the public agency may not seek permission. So the public agency cannot go to a hearing officer or a mediator and say, hey, I really want to give the parent the services, and they're refusing to agree. So those are those instances. Okay. COVID-19, most schools are, back in person full-time, but I did want to throw this slide in there because I know we have the Delta variant and we'll probably have some more, hopefully not during the year. But if the schools close, last year, the Department of Education said that all timelines continue going on. It doesn't matter whether the school building is open or closed. These timelines, it's from the date you sign the consent form, the LEA has 60 days to evaluate and give you the report. That all of these timelines will still be in effect. These are the federal timelines. After you receive your evaluation, they have 30 days to finish your IEP, not start it, finish it. So, you should be at a meeting within that time frame. They can, during COVID, ask for reasonable extensions for these timelines if they're necessary. That's a special provision for COVID when the schools were closed. If there was a reevaluation or an evaluation occurring, at the time that the schools closed, there was a question to Department of Education. Can the LEA say, okay, well, we're just going to stop evaluating because schools are closed? And PDE said, no, the timelines continue. You must continue to evaluate the student. If there's any delay, the districts are required to provide at least Title I services or other supports that they're able to provide. Again, these are all COVID related. Okay, what happens if the district evaluates your child and says, or determines something you don't agree with? Your child is not eligible. We understand your child isn't speaking, but we don't think they qualify for speech and language services. Or, we don't really see that there is enough of a delay in a reading disability. So, it could be any number of things, behavioral issues, attention, whatever your child was being evaluated for. If you disagree with the evaluation that the LEA gives you, you do have the right to ask for independent educational evaluations at public expense. And what that means is that you can ask the district to pay for a private evaluator that you choose. The private evaluators have to be qualified and to, you know, the similar, the same qualifications and certifications that are required of a school district employee, but the independent evaluator does not work for the school district. They have no connection with the district. And like I said before, it's the parent chooses that evaluator. Sometimes the districts can recommend certain evaluators. They can guide the parent towards, you know, certain evaluators. That's okay, but the parent is not required to agree to use the evaluators that the school district is recommending, so long as the evaluator the parent chooses is qualified. When a parent makes this request, the LEA has to give information about where the independent evaluation can be obtained, the agency criteria, so you know you're getting someone who has, you know, the qualifications that they're required to have, and you know, the rights to get the independent evaluation should be, you know, similar to the criteria used in schools in the LEA. So, you know, the location of the evaluation and the qualifications of the examiner also come into play. Oftentimes the independent evaluators, they can evaluate in their own office, but they have to do a classroom-based observation as part of their evaluation. Some evaluators, a lot of them begin testing since they're visiting the school anyway to do the classroom observation. They also begin testing that day in a quiet room at the school building. Sometimes school districts agree to do that. If you make a request for an independent evaluation, the school district cannot say that you have to have it within a certain time or impose conditions that are not within the statute. They can ask the parent why they disagree with the evaluation, but they can't require that the parent give a reason. So if honestly, any reason is and should be acceptable. Why do you disagree with it? Well, because I think my child does have a problem with reading and your evaluation says that he doesn't, or that he doesn't qualify for services, or, you know, my child has trouble with speech and understanding language and your report says he doesn't, and I disagree with that. So, you know, don't feel pressured to come up with a specific reason or anything too complicated. Honestly, under the statute, the school district, I could ask you what the reason is, but you know, they can't require you to give a reason. You can only get asked for independent evaluation once every time the school district evaluates your child and issues that evaluation report or reevaluation report. The independent evaluations can also be asked to be ordered as part of a due process hearing. Now, if you ask for an independent evaluation, the school district only has two choices. They have to agree, or they have to file a due process complaint. There is no secret option number 3, which I see a lot, where the school district says, we can do that. We can do it better. We can do it faster. Please let us do it. That is not an option. They already had a chance. They already tried to evaluate the student. When the school district evaluates a student, they're required to do a comprehensive evaluation. That is their responsibility. And it should not be a situation where they say, well, we didn't look into that need, but now we have a right to do it. No, they had their right to do it when they did the evaluation. If the school district files for due process, that is a hearing, and you will go to an administrative hearing in front of a hearing officer. So you may want to, at that point, find an attorney to represent you. It is a hearing, it's a trial, but you know, oftentimes you can try to resolve it through mediation also, and we'll go through all of that. But it you know, in many cases, one is necessary and would be advisable to ask for an independent evaluation.
Can I ask a question, Tanya?
Sure.
So when a parent asks for an independent educational evaluation by the provider of their choice, it says that they're only entitled to one. So say the district or the LEA does a school psychological eval, an OT, a PT, and a speech, and a parent maybe wants a combination thereof of IEs because they're not in agreement. Are they only authorized to ask for one, or is it one per occurrence?
So the best answer I could give you is the school district is required to do a comprehensive evaluation. So when you ask for an independent or independent educational evaluations, you also have the right to ask for a comprehensive one. So, you know, when they're independent, it could be any combination of them. It could be speech and language, OT, you know, psychoeducational evaluation, a functional behavioral assessment to check the child's behavior. So what the language says is the parent can only ask once for independent educational evaluations each time the school district issues an evaluation or reevaluation report. But when you ask that one time, you can ask for 5, 6, you know, any number of independent evaluations that you think are necessary for your child. So, and you don't have to ask for a lot of them. But anyway, so you can only ask one time. But the single time that you ask, you can ask for 5 of them.
All right, say for example, I ask for IEs and the district does everything, but maybe they missed the functional behavioral assessment. Am I entitled to ask for an IEE at that time, or does the district get to do it first before I get to ask?
No, so that's what I was talking about a little bit before. They only have 2 options. They can say yes, or they can go to due process. They don't get the, oh, we forgot to do that as part of our comprehensive evaluation. Please, please, please let us do it now. Or sometimes they say, nope, we're entitled to do it because we didn't do it the first time, so now we can do it. You know, that's not what the statute is about. The district is required to do a comprehensive evaluation the first time or when they're evaluating. So if they missed a functional behavioral assessment and the parent says, you missed the functional behavioral assessment, I would like an independent functional behavioral assessment, or we want the school district to pay for that. That's legitimate. The school district can't say, oops, yeah, we forgot. Now it's our turn again. No, it was their turn when they're doing their own evaluation or reevaluation report.
Thank you.
Okay, NORAPs. This is a situation where the school district tells you what they're going to do. It's a 4-page document, and it has to be given to the parent a reasonable time before the district takes an action. You know, and the action could be starting special education services, changing identification, evaluating the student, changing the student's placement, or changing the program. So if they say something like, oh, we're going to take away your speech and language services, that's a change of program. That's a situation where a NORAP has to be provided. And the NORAP is a document that tells a parent exactly what's going to happen. We're going to take this away. We're going to give this to you. We're going to change your child's classroom. We're going to put your child in a different school. You know, so that's something that the parent has to have in writing, and it can't be, you know, at the last minute. They can't give it to the parent and say, we're going to do it tomorrow. The parent is to be given reasonable time, 10 days before anything goes into effect. So this is also a time when you get your procedural safeguards, that big book of all your rights. And then the district is also supposed to tell you, well, if you need assistance or if you need explanations of anything, there's something significant happening right now. There is a list of agencies at the very last page of the NORAP where you can call for help. Places like the Education Law Center is listed. I think the ARC is listed. Just different agencies that are there where a parent can call and ask for help. So that's, you know, the information that is to be in the NORAP. So the parent has 10 days to respond. Now, some parents think that if they don't sign the NORAP, then the bad thing won't happen because, the parent isn't signing it. The NORAP is not the same as a consent form. A consent form, the district has to give you to ask permission, and then they can't do anything unless you sign it. The NORAP is different. The NORAP is a notice telling you this is going to happen in 10 days. Here's your notice. And so the parent does have to sign it. Now, signing it doesn't mean you're agreeing with it. There are boxes at the end, at the back of the NORAP, where you can state whether or not you agree or disagree with it. If it's a change of placement or, some services are going to be taken away, as a result of, what the school district is telling you, if you reject it and ask for mediation or due process on that NORAP, you keep your services. You keep your services until the mediation or due process is over. So I tell a lot of my clients, they're walking into an IEP meeting. They said, we're really scared. We think they're going to change the school or they're going to take away a service. I always tell them, don't be scared. The bad thing is not going to happen at the meeting. They have to give you this notice and then you have 10 days to take some action. So, it's important that parents who are attending this presentation also know that, don't be afraid of the IEP meeting. Ask a lot of questions, figure out what's happening. You still have 10 days to either agree or if you disagree to stop kind of the bad thing from happening. Unless there's a disciplinary removal for very extreme behavior, which we'll also talk about. But in all other circumstances, you do have the 10 days. Okay, and the NORAP has the same requirements as the procedural safeguards: understandable language, native language, and it has to be communicated to you if you're not able to read the document and understand it yourself. Okay, IDEA also allows the school district to send documents by electronic mail. So, they don't have to hand it to you personally. I know a lot of districts put it in your child's backpack. They can send it to you electronically. I tend to like that option because it's easier for my clients to just forward things to me and I can get a copy of it immediately. The district is required to be cognizant of equity considerations. They have to be mindful that, some parents are not technologically savvy. Not everyone has a printer at home or a scanner, so you really can't assume that the parent is technically savvy or has access to Wi-Fi or has a, functioning computer. Some parents are doing a lot of this stuff on their cell phones. So, if you're a parent and, receiving it electronically is a problem, you have the right to receive it in another format. Again, the purpose of the statute is to give the parents rights and to give you notice of rights. And if you can't access it, then the school district is required to give it to you in a way that you can access. Okay. And electronic signatures were allowed during COVID and they're still being accepted now. So
I have a question for you from a parent.
Sure.
Parent was asking, if an LEA chooses to reduce a service, are they required to provide prior written notice?
yes. Yes,
When-
if it's one of the services in the IEP. So for instance, if we're talking about speech and language services being reduced from 30 minutes to 15 minutes, that's something that, yes, you should get a NORAP and advance notice about that. If they're changing your placement, yes, absolutely. If the school district is changing your child's reading program from one program to another, they're not required to give you that notice. So, I guess it depends on the type of change that's occurring. But if it's something in my previous slide, something significant like a change in placement, they're stopping services, they're reducing services in the IEP, those things are important. You should get a notice.
Now, if I have a reading program noted in my IEP, would they have to give me prior written notice?
No,
Really?
no, well,
Only because if I had Wilson reading program in there and they decided to eliminate that and then say, go to reading mastery.
Well, I'm gonna change my answer. If it's in the IEP,
Okay,
you have an entitlement to it, to a continuation of that service. Which is why many districts don't put these programs in the IEP, because sometimes it does give the district flexibility in terms of, if one program isn't working, then, they'll move to another program that is working. And many times that's a good thing. You don't want to keep using a program that's not working and delay the change of it for an IEP meeting. But if it's a program like Wilson, Orton Gillingham, fast forward, these programs that are scientifically developed, they're proven to work. They are programs that, tend to be highly desirable. If it's in the IEP, you do have a right to it. And if they try to take that away or reduce it, if you're supposed to get Wilson 5 times a week and they reduce it to 3, that is a situation where they do have to notify you in a NORAP, and you have the right to the 10 days, to not agree with it, ask for mediation or due process, and you get to continue to receive those services until those processes are over. Okay. Okay, private school. There are 2 instances where school districts pay for private school. The first is voluntary. If the school district agrees to place, and 10 points for any parent who can identify this picture. So, but if the school district voluntarily decides to place your child in a private school, that is a way to get a private school placement. That agreement happens at an IEP meeting. A NORAP has to be issued, and this because it's a change in placement, and the school district has to provide transportation to that school regardless of the distance, whether it's an hour away, 50 miles away, wherever the placement is that, both parties agree to, the district is required to provide transportation. So the other way that schools might be required to pay for private school is tuition reimbursement. This occurs when there is no agreement between the parent and the school district at an IEP meeting. The school district says, well, we can offer services here. And the parent says, no, I don't think your program is appropriate for my child, and I must now find a private school to send my child to. Under the statute, the entitlement to parent is a reimbursement of tuition. So, what the parent has to do is find a school, apply and take the risk, pay the tuition, enter a payment plan, but they do have to obligate themselves to pay that tuition for the student. Now they can come back and file a due process complaint against the district to try to get tuition reimbursement. And, of course, they can talk to the district before filing anything to try to see if the district would agree to voluntarily pay for or, reimburse for that private school placement. If the parent decides to place the child on their own, there are limitations on the bus transportation. It's 10 miles from the district boundaries. And the difference is that, in my previous slide, the school district was in agreement. They said, yeah, we're going to send your child somewhere else. We think that's an appropriate placement. They're required to transport. If the parent on their own says, I don't think your program is appropriate, I must send my child somewhere else now. Under the law, the school district is only required to transport within 10 miles of the district boundaries, not 10 miles from your home. Your home may be 5 miles from the district boundaries. So, so there are district boundary maps on the internet. Find your district, figure out where those boundaries occur, and then go 10 miles in any direction from that boundary, and to see if your school falls within that 10-mile limit. If the school is within that 10-mile limit, the school district is required to transport your child, even though they didn't agree to place them there, if they're also transporting other children to other private schools in your area, for instance, parochial schools or, any other private school, but they would be required to transport your child also. The school district isn't under the statute. So the statute itself says the school district doesn't have to pay for private school tuition if the parent places the child themselves. So that's the starting point. So unlike the rest of the IDEA where it says, these are your rights, parents, and the school district can't take them away, these are the rules around that. Tuition, private school tuition is a little different. The statute says you're not entitled to private school tuition unless, and then there are a lot of exceptions. So the starting point is you're not automatically entitled to this. So then you start looking at, okay, what are the requirements? One requirement is that the child should have previously received special education service and special education and related services from the LEA. These are kids that have IEPs, 504s, these are kids that are getting special education services. So, one of the questions is, what if my child doesn't have an IEP? What if the disagreement was, I think my child needs special education. The district says, we evaluated your child. We don't think your child does. That parent can still get tuition reimbursement from their school. And, the Forest Grove, the Supreme Court, it was exactly that situation. The district had evaluated the student. They said, you don't qualify for services. The parent says, yes, my child does qualify for services. And they found a private school for the child. So the school district said, well, you never received an IEP, so you're not entitled to tuition reimbursement. The Supreme Court said, not necessarily. That child was, evaluated by the district and was later found to be eligible by an independent evaluator. So this child later became identified. So that's a really nice decision because it includes kids that should have been identified, the kids that are falling through the cracks and don't have any services. So it does give some recourse to the parents to have access to tuition.
I have one comment and two questions. First comment is your pictures from Harry Potter.
Bingo, 10 points.
Okay. Katrina asked, if a specific program such as Wilson Reading Program is included in the IEP, is there a specific area of the IEP where it should be listed or included?
It could appear in a couple of different areas. It could appear in the annual goal. And it could appear also in the specially designed instruction. It could also appear in the present educational levels, where they're reporting how your child is progressing and going through. But those are the areas generally where it would appear.
Another question from Christina was, can you have them reimbursed for a portion of daycare that counts as preschool if you send them to a private daycare versus an IU preschool?
So that depends on your needs, your child's needs. If your child's disability, these are preschool children, if your child has a disability where preschool education should be part of their program. So, I think the best example would be a child, with autism, where social skills are necessary. They're very important, especially, at that age, So if your child needs a preschool setting in order to address their needs, then yes. If your child does not need a preschool setting in order to address their needs, then no. Okay.
Thank you.
Okay. So we have transportation and some of these conditions where the school district would be required to pay for or reimburse for tuition. Okay, so it's a child who's identified or eligible for special education services. A hearing officer or a court requires tuition reimbursement because the school district did not give your child a free appropriate public education, FAPE. So the school district's program was not appropriate, and so these three things have to occur, and the private placement is appropriate. So if I'm removing my child because I think my child has a reading disability and needs very highly specialized reading services, and the private school I choose doesn't have it, even if I can show that the school district should have given it to me and that my child does qualify for services, if my private school is not appropriate, doesn't provide those services either, then the parent is not going to get tuition reimbursement. So the private school placement is not required to meet the state standards that apply to the public schools. And I hear this a lot in my practice, not all of your teachers are certified. That's not the least restrictive environment, they're not required, they don't fall under the same guidelines. They don't have the same requirements. And that's a very important part of the statute, because a lot of these private schools are specifically designed to address the needs of children with disabilities. So, they're not trying to replicate a public school. They're trying to create a specialized environment for your child's needs. Okay, so let's say you fulfill the 3 criteria. You show that your child is eligible for services. You show that the program was not appropriate. You get a hearing officer to say, district, you have to reimburse and your school is appropriate. Tuition reimbursement can still be denied or reduced if certain criteria are not followed. And so these are very important criteria. I actually, instead of Hogwarts, I should have had a minefield, through tuition reimbursement, because there are all these things that could happen. Okay, so at the most recent, so the parent is required to give the school notice that say, hey, I don't think your program is appropriate, and I'm thinking of taking my kid somewhere else, and I want you to pay for that. That's essentially what that's something that the parent has to do. They have to tell the district, your program's not appropriate. I don't agree with it. I'm thinking about taking my child to a private school, and I'd like you to pay for it. That last piece is important because it's not always implied. The parent says, well, I don't think your program is appropriate and I'm taking my child to private school. That does not meet the criteria. You have to ask the school district to pay for it. Otherwise, there's not a notice that you're asking them to pay for it. So, so that's essentially what the ABC is. You do have to tell them at the IEP meeting, it's one of the ways to fulfill this, that you don't agree with the IEP, you don't think it's appropriate. And then you can describe why. And like your reasons for disagreeing with the evaluation, you don't have to go into great detail. You're the parent, you're not a, someone with a, higher education degree in the specific area that your child has a need. You're the mom, you're the dad, you're looking at a program and say, I don't think it's appropriate. You can say why, I don't think the reading program is going to address my child's needs. You're not giving my child speech and language services, and I think he needs them. Whatever reason you feel the program is not appropriate is a perfectly fine reason to give to the district. And then again, you tell them that you intend to take your child to a private school, enroll them, and you want the district to pay for it. If you've already enrolled your child in a private school before you tell the district these 3 little facts, you won't get tuition reimbursement. It has to be, you're putting the district on notice of something that's going to happen. Okay. What if you've already had your IEP meeting and it's the middle of the summer and you're thinking about the program, and you're not going to be at another IEP meeting before you decide to change your child's schools? You can fulfill this requirement by sending the school district written notice. You tell them exactly the same thing. I don't think your program's appropriate. These are the reasons why. And I'm thinking of enrolling my child in a private school, and I want you to pay for it. Same thing, but you put it in a written notice. It has to be provided to the district at least 10 business days. That's 2 weeks before you take your child out of the district and enroll them in the private school. So what does the district do with those 10 days? Under the law, that's their last chance at trying to give you an appropriate program. And, to try to give you the opportunity to have a free, education, appropriate education at the district. So during those 10 days, after this notice, that's what's supposed to happen. If you're at an IEP meeting, you don't have to, wait the 10 days. If your IEP meeting is 3 days before you're going to pull your child out, then that's enough. It's either at the IEP meeting, or if you have to send written notice, the statute wants you to give the district at least 10 business days. That's 2 weeks. And if there's a holiday in there, because there always is Labor Day at the beginning of the school year, it's really, you have to add another business day. It's 11 business days. So just keep that in mind. Some kids change schools in the middle of, like right after the holiday break. So, you have to get Christmas, account for Christmas and New Year's. Those are not business days. So you have to add 2 days, at that point.
I have a question for you, Tanya. So one parent asked, does the reimbursement for pre-K also apply for Elwyn as well if they don't have an appropriate placement for my child?
Yes. Okay, and that's ages 3 to 5, the preschool years. Yeah. Okay. Okay. There's another reason, and it really should have been Minefield instead of Hogwarts. Even if you get past the notice and, you're telling the district, what you don't like about the IEP or the program, and you found an appropriate school, it can still be denied. Tuition can still be denied or reduced if the hearing officer thinks that you have not cooperated with the school district. So the kinds of things they're looking for is, was there anything that occurred that prevented the school district, or that the school district, might say prevented them from being able to give you an appropriate program, within that critical time period before you take your child away. And so things they look for are if the school district says, okay, we want to reevaluate, let us try to figure this out and give your child, an appropriate IEP and an IEP that you agree with. And you say, nope, you've had your chance. I am out of here. The hearing officer can reduce or deny the tuition. If the school district is inviting you to an IEP meeting and you say, I'm just done with this, I'm going to the private school, that's another situation where a hearing officer could say that you're not cooperating. So, if you're looking at a tuition reimbursement situation, meet with the district. If they, ask for permission to evaluate your child, give them permission to do that. Let the school district do whatever it is they're going to try to do to rectify the situation. At the end of the day, you don't have to agree with the program or agree with the evaluation that they do. And you can still remove your child, if you've given the right notice and fulfilled all the other criteria. So that would be my best advice. Okay. Or tuition can be denied or reduced if the hearing officer finds that the parent somehow was unreasonable, either, didn't show up for a meeting, or, just anything that looks like there's no cooperation or non-cooperation, or you're being difficult, or even, the school district scheduled several IEP meetings and you keep canceling them, without good reason. So they really look at everything to see, well, was there an opportunity for the school district, that last opportunity to try to get it right? Okay, so there are exceptions to this, where if you cannot give enough notice or your behavior looks like you're not cooperating. So, and there, 3 exceptions to this. If the school district somehow prevented you from providing notice, that is excusable. The best example I could think of are, some school districts changed emails without notifying anyone, or, when they change the email, the old email doesn't tell you that there's a new email, and the parent sends the written notice to the wrong email, and district says, we never got it, So, in that situation, you can say, well, I was prevented from, being able to provide appropriate notice because no one told me that the email had changed. If you did not receive a procedural safeguards notice, that, big notice. So if you're at the IEP meeting and you say, please, I want you to pay for this private school, and the district with the NORAP does not give you a procedural safeguards notice, or if they've never given you a procedural safeguards notice, ever, all those times that they're supposed to, then the hearing officer can say, you know what, we're going to give you tuition because you were not aware of your rights. And if compliance with this notice requirement would put your child in physical harm, in danger of being in physical harm. So, the 10-day notice, if your child is being bullied and beat up every day, and you have talked to the school district and that keeps happening, and you say, you know what, I need to protect my child, that my child cannot return there for another 2 weeks after I give this notice, that's excusable. The hearing officer, will find, and you have to prove it, that this has been happening and that the school district was aware of the bullying. But that would be a situation where not giving notice would be excusable because the child was likely, in harm's way. Okay. If the parent is not literate or cannot write in English, that is also forgivable in terms of, not giving the notice. And also if there is a chance that your child would experience serious emotional harm, if you wait that period of time, that last chance that the district has to provide you an appropriate program. So, the statute doesn't want your child to be in danger in a situation where they're in a likelihood to be harmed. Okay, so the other part of the procedural safeguards is, what do you do if there's a conflict and you cannot resolve it? You've been at many IEP meetings, you've talked to the teachers, you've talked to the director, you've done everything that you can to try to address these issues. What do you do? The answers are in the procedural safeguards notice. So these are your options. You can ask for mediation. You can file a complaint with PDE. You can file for due process. And there's a portion in here that talks about what happens to your child if you're in one of these situations. So pendency really applies to if a school district is trying to take a service away or move your child to a different school, and you disagree with it. Those are the moments where I tell the parent they're supposed to give you a NORAP. On the NORAP, you can ask for mediation or due process that will prevent this from happening. And you have to do it within 10 days of receiving the NORAP. So, if that happens, the change can't occur. So when you're talking about the change isn't going to occur, things are not going to change, that's when we're talking about pendency. What happens when you've asked for mediation or due process so you can stop the change? The legislature said, okay, so there's a disagreement. The district thinks the child needs X. The parent says, no, we have to keep Y in place. What happens to the child? So the legislature said, the most fair thing to do is to keep the child in the program that the child was in before the disagreement occurred. So, so you're looking at keeping the child or keeping the services in place before the disagreement occurred. And that's what pendency is. Okay, so I'm going to go through these, just kind of describe what they are. Mediation is an attempt at trying to resolve the disagreement in a way that gives you some level of control. It's not like due process or the state procedures where you're just kind of handing it over to somebody else, hoping that they'll see things your way. At a mediation, the state assigns an impartial person who is a mediator to try to see if they can get you to agree on whatever it is the conflict is occurring. So if they're trying to reduce services, speech and language services, and the district says, well, they have 30 minutes a week and we think they need 15. The mediator might be able to kind of bridge that gap, maybe 20 minutes, 25 minutes, or maybe continue the services for a little while and then start tapering them off if certain things happen or if you see certain improvements. It's an opportunity to be creative about trying to resolve the disagreement so that you don't have to go to due process and you don't have to file a state complaint. Because once you go into that realm, you're giving the decision of what's going to happen, the outcome, you're putting it in somebody else's hands. I like the idea of mediation is good. If you can resolve a conflict before it actually goes into a hearing, that is the best opportunity for you to really control and have input in what that outcome is going to look like. It has to be free. They provide the service free, scheduled at a convenient date and time for the parent, and it has to be voluntary. Both sides have to agree to mediate. If one side doesn't want to, then you can't mediate. Okay. And your discussions during mediation are to be kept confidential and can't be used in a proceeding later. So if you go to mediation first and you can't work it out, you can still go to due process. You can still file a state or federal complaint. Whatever discussions you had during mediation are to be kept confidential. So it's really an opportunity to try to work it out and not be afraid that something you say is going to be used against you, as long as you're mediating in good faith, so that's a nice protection there. The next
Can I ask a question?
Sure.
I'm so sorry. Well, maybe you're going to be getting on it. Have there been any recent changes to the request, to mediation?
Yes. The parents can take an attorney. That is something that's new. Before the parents, if the parents were going to mediation with the school district, they were not allowed to have an attorney at mediation, and that has changed. So the parents can bring an attorney now to represent them and be part of that mediation process. So, and that is okay. The agreement, if you reach an agreement between you and the district, then the mediator is going to write it down and you get a legally binding agreement. Both parties are locked into that. So that's a really good thing. If you reach an agreement that is workable for you and the district, you can enforce it. If the district doesn't follow through with what the service is or what they had agreed to at the mediation, it is enforceable. It is an agreement, and vice versa. If the parent doesn't follow through with something that's in the mediation agreement, the district can try to enforce it as well. Okay. So what if mediation doesn't work? Or what if you say, what, I know mediation is not going to work. I've been at this, trying to resolve this for a very long time. You can go to due process or file a state complaint, or you can do both. So with this slide, I'm trying to compare the two different processes and what's available to you, kind of what the rules are around this. If for due process, only the parent or the school district can ask for due process. That's it. And like I said before, the parent, it could be it's actually would be someone who has a legal right to represent your child in a legal capacity. So it's a little different than who steps into the shoes of the parent for consent or to go to the meetings. This is different. This is a legal action. So you do need someone who has the legal right to do it. If the child does not have a parent or a guardian, a legal, guardian assigned to them, then they could assign a surrogate parent just to make sure that the student has, someone there representing them. And the state complaint procedures, it could be anyone who has a concern. So it could be you, it could be the district, it could be another agency or organization that's looking at something that's happening at the district. And, they could say, well, we need this investigated. There's something going on there. The issues that are addressed are very similar. It's, special education services and rights, your right to an evaluation, IEEs and everything at due process. The same for the state complaint procedures, and also issues raised by the public agency could also be addressed. How soon do you get a decision? So the state complaint process has to be investigated and you get a decision within 60 calendar days. With the due process complaint, it's also 60 calendar days, but it kind of breaks down a little bit. You have 15 days to try to resolve it. And then, the additional 45 days to go through the hearing and get a decision. In both cases, the parties can agree to extend that timeline if it's necessary to be able to provide enough information or call enough witnesses or, just present enough evidence, if it's necessary. Very, very important. Pendency only attaches to mediation and due process. So if you go to mediation and it doesn't work and you say, I don't want to do due process, that's too involved. I want to try the state complaint procedure. You can do that, but you don't have a right to pendency. And that's very important for you to know. If you're concerned that services are being taken away or your child is being moved to a different classroom or a different school, and you try to, address it at mediation, remember mediation or due process. So if you're first addressing it at mediation, your child no changes have occurred. If mediation doesn't work and you file for due process, still no changes will occur. If mediation doesn't work, but you go the state complaint procedure route, the change will take place. So just bear that in mind. Pendency is not always a concern. Sometimes you're trying to get services added to the IEP. Pendency doesn't matter in that situation. So you have a little bit more options. But okay, the state complaint procedures. You get the form. It has to be signed. If it's not signed, it's not considered filed. And I've listed here all the things that it has to include. Basically, you're telling the state what you're upset about and what the concern is. You say, what the school district or the LEA has done wrong, or, what has upset you about the situation or about the program. Then you do have to give facts. So, you can say, the school district isn't providing my child appropriate education, but then you have to add facts. For instance, my child needs reading and there are no reading goals, or, they need assistive technology and none was offered. Or, I asked for them to evaluate for assistive technology and they said no. Whatever the facts are that, are the basis of it. You have to put your name and contact information so the state can contact you. And if it involves violations, IDEA, FAPE violations regarding your child, then the name of the child, date of birth, the address, your address, again, the description and a proposed resolution. Like what are you looking for that would resolve the issue? What outcome? Okay. So with the state, there are certain timelines attached to. With the state complaint procedures, you have 1 year to file a state complaint after something has happened. With IDEA, that should have been on the previous slide, you have up to 2 years, and then there are a couple little exceptions around that. You get a copy of you have to give a copy of the complaint to the LEA at the same time you're filing it with the state. And then I have the address for you here. It's also in your procedural safeguards notice. So but the address of where to contact and where to file these complaints are right in your procedural safeguards notice. They're right on my slideshow here too. Okay, what happens within the 60 calendar days? An investigator is assigned to your case. They give you a chance to add information, present more evidence, identify witnesses. If you think there's somebody that, has information about this that can support your allegations. They also, it's an investigation. So they also talk to the school district or the LEA, who's ever serving your child. They give them a chance to respond to it, identify a witness, give evidence, review documents, and they look into all of the relevant information. If there's anything that the investigator needs that you think is necessary or a critical part of the investigation, give it to them. If the school district has it, you can tell the investigator about it. Oh, the school district has this, I don't have a copy, but you should ask them for it. And then the investigator reviews everything and they issue a written decision. It has to have the findings of facts and conclusions and the reasons that for their determination, their final decision. So you should be able to understand what facts are included and how they arrived at their decision. Like I said before, it can be extended for exceptional circumstances or if everyone agrees. Okay, so if the final decision finds that the school district or the LEA has done something wrong, they will, kind of identify technical assistance activities. If the teachers need training, that will be included in the decision. Any corrective actions and things like that would be included in there. So what do you get if the state finds in your favor, if they say that you're right? You could, if it's a failure to provide services, they'll tell the school district to give you the services or give your child the services. If you've missed services, they'll say you're owed compensatory education. They identify what should be provided going forward after the dispute. Okay, so important things, because I said you can file a state complaint or due process, or you can do both. It's completely up to you. And you don't have to go to mediation first. This is absolutely your choice. But what happens if you file the state complaint and then you said, you know what, I just want to go to due process. I'm going to file a due process complaint. Or you filed the state complaint, they give you a decision and you don't agree with it, and you want to file for due process. You can still file for due process. These two, it's not an either or. You can choose to do both. But if there is some overlap between what you're complaining to the state about and your due process complaint, the state stops. Under the statute, the state has to stop pursuing whatever claims are the same. So if it's only, for instance, one claim that you filed in both due process and the state complaint process, then the state is going to stop investigating. They won't issue a decision. They will say, you have gone to due process. We're going to let them decide. If you made many complaints to do, your complaint to due process involves a lot of different issues. And one of those issues, well, I'm sorry, I'm going to reverse it. If you presented a lot of issues to the state, and one of those issues you've taken into due process, the state has to stop investigating that issue that went to due process, but they can continue to investigate everything else. So it's the overlap, whether it's a complete overlap or a little bit, just maybe one issue or two issues. Whenever there's an overlap, the state has to stop investigating it. Now, what if the state issue a decision and you disagree with it? What happens in due process? The decision of the state is not binding on the due process. The hearing officer can disagree and the investigator didn't find in your favor. Don't lose hope. Don't be disheartened. You can still file a due process complaint about the same issue. Have the hearing officer take a look at it, call some witnesses, and just kind of go through that process. All is not lost. You can still pursue it. The reverse is not true. If you went to due process and a hearing officer made the decision, the state doesn't review it and they're not going to overturn it or anything like that. So, so there is a difference. Okay. All right. Due process complaint. This is a process where the previous mediation and state complaint, you don't necessarily need a lawyer. At mediation, you're now allowed to bring a lawyer. With due process complaint, you don't have to have a lawyer either. You can represent yourself. I do not recommend that in any capacity. It is too complicated. The programs and the questions, to ask the witnesses are very complex. So if you're in need of an attorney or if you're going into due process, I do encourage you to try to find an attorney to represent you or an extremely knowledgeable person like Benita or, one of the advocates from ARC. They're a fund of knowledge. They know their stuff. But so, try to have someone with you at due process. These hearings are very complex and they're hard to go through, even for me as the attorney. They can be emotionally draining and a lot is at stake. So, okay. So you have 2 years. So from the date you file your complaint, you can go back 2 years asking for compensatory education or whatever the remedy is. There's 2 exceptions to that. You can go back more years if the school specifically misrepresented that they addressed your concern and they fixed it. So, or really just address the concern. If that is that's very hard to prove it. That's a very, very high level of intent or scrutiny that the hearing officer applies to this. The specific misrepresentations are ones that they look at it for intent. The teacher, whoever said, whoever told you it was addressed, you would have to show that they said that with intent to mislead you, it's almost intent to cause harm. It's a very, very high standard. It's very difficult to prove. The withholding of information is also difficult unless you're alleging that they didn't give you the NORAP or that procedural safeguards notice that they're supposed to give you. In those situations, you can say, well, I didn't get my procedural safeguards notice. I want to go back more than 2 years, in terms of looking for a remedy.
Tanya, if you don't mind, I'm just gonna make a real quick announcement.
Sure.
I know we're close to our scheduled time and we're gonna be running over, but for anyone who has to leave, we just want to say thank you so very much. Email Lisa Johnson and we'll be sure to share this recording with you as well. All right, thank you so much. I'm here for the end because it's good stuff, but I just want to share that.
So when you file a due process complaint, it's a very similar to state complaint. You have to give it to the school district at the same time you're filing it. You have to identify the child, the address, date of birth, the nature of the problem, facts relating to it, and a proposed resolution. The due process complaint cannot begin, the hearings cannot begin until you've identified all of these things on the slide. So if the school district receiving your complaint, or if the school district has filed a complaint and you're receiving it, whoever's receiving the complaint has 15 days to tell the hearing officer that they do not think that this information was sufficient. If that happens, then the hearing officer will, within 5 days, they have to make a decision and then tell whoever filed the complaint whether it was sufficient or if it wasn't sufficient. typically the hearing officers give you a chance to add information or correct whatever it is that wasn't sufficient. And that's called an amendment. So if there's a sufficiency challenge and the hearing officer says, we need more information, you can amend your complaint. It restarts all of the timelines. You can also amend your complaint at any time if the other side agrees. So I recently had a situation where we filed for due process for compensatory education going 2 years back. Afterwards, the program still wasn't, wasn't appropriate. The parent was still very concerned. So the child was, the parent removed the child, and the child is now at a private school. So now we have a new claim. It's the tuition reimbursement claim. An amendment was necessary because there's a new claim now. Something happened for which you need a new claim. That would be a situation where an amendment would be made. Once that amendment went in, it restarts all the timelines. Okay. The other side has to respond to your complaint within 10 calendar days. They have to explain what happened, agree or disagree with your allegations, and just kind of describe why they agree or disagree with it. For districts, typically giving you a NORAP sets forth the information that's in there. So if the district has given you a NORAP about the thing that you're complaining about, that tends to be sufficient, to serve as a response from the school district. I typically get a response anyway from attorneys after we file the due process complaint. Within 10 days, I expect to receive a response, with the attorney identifying, their disagreement, why they disagree, and, and some of the factors of why they're disagreeing with it. Within 15 calendar days after the due process complaint, the parties are required to try to meet and resolve it. That's the resolution timeframe. And that's required. So it's not a question of, whether it's going to happen. I guess if one side doesn't want to have a resolution meeting, that's not enough. You have to have it. If both sides say, we can meet, but we're not going to resolve this, you can waive the resolution meeting. So both sides can waive it, but both sides don't have to agree to have it. It's not like mediation. At mediation, both sides have to agree to do it. It's voluntary. The resolution meeting is not voluntary unless both sides say, nah, we don't want it. It's not gonna help. So the due process hearing cannot occur until after the resolution meeting occurs, or after the waiver, until after the waiver. So if the parent does not participate in the resolution meeting and the LEA can demonstrate that they've tried to invite and they've reached out, and they've tried to get this moving, the LEA can ask the hearing officer to dismiss the complaint because the parent didn't show up for the resolution meeting, they didn't respond, and after several attempts. If the school district does not participate in a resolution meeting, the parent could ask the hearing officer to just go to due process. Like I said before, due process cannot start until that resolution meeting occurs, until after it occurs. If you're the parent who filed a complaint and the school district is not engaging in a resolution process, you don't have to wait forever, for that meeting to occur. You can tell the hearing officer, look, I've waited, it's beyond 15 days, we don't want to wait anymore. We want to go to due process. So that's an exception to that. With the resolution meeting, you can still try to resolve the case, even if it's not resolved during those 15 days. You're not going to go to due process on the 16th day. That gets scheduled a little later. There's a little bit of lead time. So there's still an opportunity to try to resolve it, which I always recommend. You can ask for mediation still if you're in a due process situation. And you can also ask for, and I forgot to include it here, a hearing officer conference where a different hearing officer that's not assigned to your case can look at some of the pertinent facts and kind of give the parties an idea of where they think the case is going to land. That might open up some discussion between the parties to see if you can still resolve it. If you're able to resolve it before the due process hearing, you can get a written settlement agreement. It's signed by both parties, and under state law, after you sign a contract, you have 3 business days to change your mind, basically. So you can void your signature within 3 business days. But if you've reached an agreement that, you're in agreement with, oftentimes it's not the best. It's not everything that you've asked for. It's always a compromise. But sometimes it's better than rolling the dice and letting the hearing officer decide the case, because, they might not find in your favor, or they might not kind of reach the type of resolution you could get maybe by negotiating or going through mediation. Okay, you can have a lawyer at a hearing. You can represent yourself. I don't recommend it. You can have an advocate, as I said before. You can call witnesses. You can ask the district to produce witnesses. You have the right to cross-examine. This is a trial. It's not as fancy as what you watch on TV, but it is a trial. There's a court reporter there. There are witnesses there. You can call the witnesses. You can cross-examine them. You can ask for records of your child. Any record the school district is going to use, you're entitled to receive before that hearing so that you can prepare. If the school district doesn't give you the records or doesn't identify the witnesses, at least 5 business days, 1 week before the hearing session, you can ask the hearing officer to exclude the witness or the document because you didn't get it with sufficient notice. After the hearing, you have a right to get a copy of the transcript and a copy of the decision. The decision also should have findings of facts, so you know which facts the decision is based on. The decision also has to be based on substantive grounds. The hearing officer has to explain why and how they got to the conclusion that they got to. Procedural violations in and of themselves are not enough to show that your child has been harmed. I should have received the IEP within 30 days of that evaluation, but I got it on the 31st day. A hearing officer is going to say, well, I don't know, that really interfered with your child's rights, and even though you got it a day late, I don't see a lot of harm. But if you get an IEP 3 months after that evaluation is complete and your child didn't get services in that time that they needed, that is a substantive issue. It's not just a procedural violation. This has harmed your child. So that's what, they mean between the difference of procedural violations and substantive violations. Sometimes the school district doesn't follow the letter of the law in terms of the timing and the things that they're supposed to do, but you also have to show us what harm did it cause to your child? How was your child affected and denied an appropriate education or access to an appropriate education? If the parent wins at due process, the parent is entitled to reasonable attorney's fees and costs. So if they had a lawyer, they can ask the school district to pay their lawyer for that due process. Both parties have 90 calendar days from the date of the decision to file an appeal, and that appeal can be made in state Commonwealth court or in federal court. I went through the pendency and stay put, so I'm not going to dwell on this too much. Only applies to mediation and due process requests. Remember, when you get that, Nora, if within 10 days you ask for mediation or due process, your child stays in the setting or continues to receive the services until those processes are over. Okay. If the complaint involves your child's first admission to a public school. You're trying to get your child into the public school, and if the public school says no, and I think that was hard for me to try to think of an example. But if you file for due process, then the child goes into the public school setting with the parent's permission. The pendency, the idea of pendency is that you're trying not to harm the child or deprive the child of education during the time that everyone's arguing about the program. If your child was in the 0 to 2 range and they're transferring into the 3 to 5 preschool range, and they had services before, but now there's a disagreement about the services that the IU wants to provide, pendency applies to that as well. Your child should continue to receive those services while the dispute is still getting resolved. Now, you don't have to continue with the services if the parent and the school district come to an agreement about what the pendant program is going to look like. So, so that's an exception. As I said before, pendency, there is an exception with disciplinary reasons, and we're going to get to that very soon, when pendency does not apply, when you can't say, wait, you need to keep my child in that placement or in that school setting. There's some disciplinary instances, very few, where the district can say, no, we need to remove your child right now, and we can fight about it after, but the placement will change. Discipline. Okay. The procedural safeguards notice also has the disciplinary procedures and the manifestation determination procedures. And we're going to go through that with the slides, but okay. The procedural safeguards notice talks about disciplinary exclusions. That's when, your child is excluded from education. So, it applies to violations of the school code of conduct. Students can be disciplined by schools. There are a few exceptions when they, cannot be, and I have them on the next slide. But the school district, if there's a violation of the school code of conduct, the district can discipline the child. It's kind of presumptive. And then there's some exceptions around that and some protections built in. So the disciplinary rights are not about, can the district discipline my child? It does turn into that. And I am going to go through that in the next slides. But part of the question is, okay, well, they can, except for certain circumstances, but for how long? How many suspensions can they give? How many consecutive days can your child be excluded from school or not have access to their education? When is it allowed? When can they be excluded from their education? When it's not allowed, and and once you exceed these timeframes, we're talking about time limits and what happens before this time limit, what happens after, after that time limit, when can your child have access to educational services again? So it's going to become a little bit clearer as we go on, but okay, these are the exceptions. The previous slide said the district can discipline your child, except for certain circumstances. If not disciplined, they can exclude your child from education. So if your child has an intellectual disability, any suspension or removal is considered a change in placement. So the disciplinary exclusions are looking at, like, when have you changed a child's placement? When are you keeping them away from education so much that you've actually changed the child's placement from their school setting to something else? So it's the question, when does that happen? Like, when is this change in placement actually taking effect? If you have a child with an intellectual disability, it's the first day. If that child is being suspended, that's a change of placement. the school district has to notify you, they have to give you an RP. There's so many protections that just kind of kick in right away. Some of my clients tell me, I heard, a child with an intellectual disability can't be suspended. Technically they can, but that suspension is a removal, it's a change in placement. There are so many protections just kind of fall on the district and on the child that it doesn't occur, so you really don't see children with intellectual disabilities. You shouldn't see them getting suspended, because those are removals, even for one day, even for a half a day. Anytime you're taking that child out of the educational setting, that is a change in placement. And again, the protections really, they come down immediately. If your child's behavior is part of a behavior support plan, your child should not be suspended for those behaviors or disciplined for them. And this happens a lot of times with kids with ADHD, executive functioning issues, attentional issues, sensory processing, or students that, have frustration management needs and they don't know how to communicate. Once they're frustrated, they say something to the teacher that, is a violation of the code of conduct. If those behaviors are part of your child's identified disabilities and part of a behavior plan, your child should not be getting disciplined for that. That is the purpose of the behavior plan, is to teach your child how to change that behavior so that, they can improve, the way they're interacting. If it's a manifestation of your child's disability, that's a little bit kind of overlaps with the behavior plan, because, that that's your child's behavior and it's related to their disability, you shouldn't be disciplined for that. There's specific protections a little later on that we're going to go through. If your child does not have an IEP yet, and you think they should, there's some protections around that too. Your child should not be excluded from school if you can prove certain things. There are also, the school district does not have to exclude your child. They're not required to. There are some unique circumstances, that the school district can meet and say, what, we're not going to impose these codes of conduct, these punishments, because there are unique circumstances around this. And, we're just not going to do it. So the school district does have that option under the statute. Okay. So as I said before, a lot of the protections around here center around how many days, how many consecutive days, how many total days. And there's certain things and protections before, during, and after you meet these time limits. So we're really looking at how many days and kind of what happens and what protections do you have. So the before, during, and after really relating to the number of days, number of exclusions, and from the school setting. So your child can be excluded. I'm going to use the word suspended. Sometimes they're placed in a different classroom or a different school placement, but the school district can do it for up to 10 consecutive school days a year without all these protections kind of kicking in. So 10 consecutive school days. On that 11th consecutive school day, those protections kick in. There's a lot of stuff that needs to happen. But, if they're suspending you or, kind of putting you in a different setting, a placement in school for 3 consecutive days, that's okay. 7, that's, okay, before these protections start kicking in. At 10, they kick in. So, okay, what if your child isn't getting suspended for consecutive days, but it's like every three or 4 days, or every week, or 3 times this month, and then 3 times next month. If those suspensions or exclusions add up to 15 days in the same school year, that's the 16th day is a change of placement, the protections kick in. So, so you're really looking at, how many days and whether they're in a row or whether they're, throughout the school year, but it all has to be in the same school year.
Question, Tanya.
Sure.
What happens if instead of my child being suspended, but the school is always calling me to pick up my child because they're exhibiting problem behavior?
So that is, it's a good question. Is it a disciplinary exclusion? No, because the disciplinary, if it's discipline, it has to violate a code of conduct. They have to documents and paperwork and all of that stuff. So, but if they're calling you to pick up your child, it is an exclusion from school. They are, removing the child from their educational setting. So, it's a little different. The manifestation determination issues don't kick in. You're really looking under the disciplinary exclusions are disciplinary related issues. And it's a situation where the school district has to identify which code of conduct, this is what we did, this is what happened, they have to document it. And, so I think that, I think it's an excellent question, honestly, because if the school district isn't following the disciplinary procedures and documenting it, and, it may look like, oh, they're doing my kid a favor because, they're not kind of papering their educational file and all these disciplinary referrals and suspensions and all that stuff isn't occurring. But on the other side of that, if that's happening for more than 10 school days, consecutive, or 15 total in a year, you are really looking at a situation where your child is being deprived of education. So it doesn't necessarily fall in this category, but it is something that needs to be addressed in the IEP. You should be looking at the behavior plan, the positive behavior support plan. You should be asking for evaluations. Functional behavioral, I would ask for an IEE, a functional behavioral IEE. If the school is always calling you to pick up your child, they don't have the right program for them, or they're not implementing it. So, okay. So before these, during this time frame, and I called this whole time frame before you reach these limits, the school can suspend you, they can put you in another setting, they can put you in an appropriate interim alternative educational setting. That requires a meeting by the IEP team, because that is a change, but that's something that's permissible as long as it doesn't turn into a permanent thing or doesn't exceed these days. If your child is being suspended, are they required to receive educational services before you get to these limits? This is all the before. We're in the before land. No educational services are required. Your child might be required to make up schoolwork and exams, if they occurred during that time frame. And the types of discipline your child can be subjected to has to be the same as the district applies for every other child who does not have an IEP. So there shouldn't be discriminatory treatment occurring here. Okay. What if, okay, so this only applies to the 15 cumulative days, but because after 10 consecutive days, once you get to that 11th consecutive day, the protections come in. But what if you're getting suspended every now and then, and you're looking at a situation where you're looking at the 15 cumulative days. After 10 of those, then the school district has to, determine, they have to provide you some services, and that decision can be made by the school, the teachers. They can decide, and that happens after the 10th day of the non-consecutive time frame. What services you're getting, the child is going to get, and how are they going to continue to help the child, make progress towards their goals. Now this is only during those additional days between 10 and 15, where the school district has to do something to make sure that the child is having access to their education. Okay. So, so after, this is the after part. So after you've met the requirements, it's either the 11th consecutive day or the 16th day. If it's not consecutive, that's a change of placement. And that's why I keep saying these protections come in and they're automatic. once you're in this realm of the after the time frame, the school district has to follow some very specific procedures in addressing your child's needs. So for instance, if your child is suspended for 11 days in a row, before that 11th day, the district has to have an IEP meeting with you, because on that 11th day, that's the change in placement. That's your change in placement. And, and they have to have a meeting, they have to notify you, they have to give you an ORAP, they have to talk about the behavior plan, they have to figure out what's working and what's not working. As I said, there are a lot of protections that, come into play here. If the time limits are exceeded and these procedures are not followed, then that's an illegal change in placement. That is something that, that's a significant violation. And when you talk about change in placement, it can be, your child could be in the same school, going to the same classes. Their everyday program might look exactly the same. It's not what the statute talks about in terms of change in placement. What it's thinking is, it's that after the 15 consecutive days in the school year, that's enough of a pattern to create a change in placement. They're depriving you of education at that point, even if you're going to the same school when you are allowed to go to school, you're in the same classes. It's just the number of days are too significant. In school suspensions count as suspensions. Okay, the child, he doesn't, your child doesn't have to be home or going to, their typical childcare when they're not, when they're suspended from school. In-school suspensions also count, because during in-school suspension, they're not accessing their education. So that's what we're looking at. Okay. After this time frame is exceeded, the school district has to have an IEP meeting. They must meet with you to determine whether the program and the services they're providing are appropriate. They must consider whether a functional behavioral assessment is necessary. Another one, because if your child has already had one, it's not working. The behavior plan isn't working. There's something that is not working, that's not addressing your child's needs. They also must determine whether the functional behavior plan might be okay, the behavior support plan might be fine, but maybe they're not implementing it. But these are the types of considerations that have to occur at this meeting. You also, so they address the IEP, and they should be addressing the positive behavior support plan, because these, we're talking about behavioral issues. The school district has to issue a NORAP at that point. And these are all kind of the protections that come in just when you hit that limit. Okay. The other thing that the school district has to talk about is whether the behavior is a manifestation of the disability. So, if it's not if it's in the behavior plan and everyone knows, that this is what your child does, it may be an easy response. Like, yes, look, it's in the behavior plan. It's identified in the functional behavioral assessment. These are the behaviors or function of the disability. It's a manifestation of the disability. This is how my child behaves because of the disability. But if the violation of the code of conduct is not a manifestation of your child's disability, then the school district can continue to discipline your child just like they would discipline any other child in the school. If it is a manifestation of your child's disability, they cannot continue to give you the same disciplinary measures, because that would be a change of placement. So, they have to reevaluate, they have to look at the functional behavioral assessment, they have to look at the behavior support plan. They cannot continue to just issue suspensions after that 15th day or after the 10th consecutive day without looking at your program and trying to figure out, what is wrong, like why it isn't working. Okay. That meeting has to occur within 10 school days of that limit. Like once you get to that point, I've listed here the members that have to be at the meeting, the information that has to be reviewed, and just what should be reviewed and talked about during that meeting. So how do you know if it's a manifestation of the disability? So you have to look at the behavior. And the question is, was it caused by, or is there a direct and substantial relationship to the child's disability? If your child is impulsive and what violated the code of conduct is that they left the school building because they were impulsive and they got frustrated and that's what they do, it's all part of the disability, it's how they manifest it, then the district cannot continue to punish your child or, exclude your child. They can't change the placement. They have to address the IEP. So if it's a failure to implement the IEP, then the school district has to take some very proactive measures to make sure that that IEP is getting implemented. Okay, and I've gone through these just now. Okay, if it is a manifestation of the disability, then the child continues in their previous placement. Now the parent and the school district can talk and agree about maybe changing the placement, but you're not required to. If the behavior is a manifestation of the disability, the child stays in the placement where they were because their IEP is being addressed. Okay. So on that 11th day again, or that 16th day, you get a NORAP procedural safeguards notice, you get the IEP meeting, they have to talk about the behavior plan. Okay. What if your child doesn't have an IEP and they're violated the code of conduct and the school district is talking about changing your child's placement or, changing the building that they're in or changing the classroom that they're assigned to. And, you don't have an IEP. Your child could still be protected by exactly the same protections of children with IEPs under certain circumstances. So if the school district had prior knowledge that your child should be a kid with a disability, should have an IEP, or has these needs, and you think they should be protected under this statute, then you could get the same protections as if your child has an IEP. So these are the things you have to show. You have to show from the parent that you expressed your concern in writing. So that could be an email to the teacher. I'm very worried because my son runs out of school, out of the classroom, talks back to the teachers. I'm very concerned about this behavior. I think my child might need an IEP. And you have to have sent that to the teacher or an administrative personnel, the supervisor of special ed or the director of special ed, someone who supervises the teacher. Or if you've asked for an evaluation, you're in the middle of waiting for the evaluation to occur, and there's a change in placement situation happening, your child, and you can prove that you've made that request, your child is protected. If you haven't sent the email and your child isn't getting evaluated, the other way your child can be protected is if the teacher or another school district personnel express concerns about the behavior or the pattern of it to one of the supervisors. In that situation, your child can also be protected. Okay. When does a school district not have knowledge? The statute says that you cannot say that the school district had knowledge of the manifestation or the potential need for an IEP if the school district wanted to evaluate your child and the parent didn't provide consent. Or the school district offered an IEP and the first IEP, and the parent said, I'm not going to provide consent for the first IEP. Or if the student was evaluated by the school district and the school district said they're not eligible for services. So those are situations where the school district is deemed not to have knowledge. Now that third one, if you disagree with it, you should be filing for mediation or due process, to kick in those protections. So that's what I would suggest. If the prior knowledge is not established, then the school district can continue to discipline your child, change the schools, change their setting, in the same manner that they would for other children. Okay. The school district can still report your child. If your child's behavior is a crime, they can report it to the authorities. If your child's behavior causes them to, go before a magistrate judge or have some other criminal proceeding, the IDA doesn't stop that. That is a separate system, and that could occur. What I typically tell parents, if you're in that situation and you think your child's disability, affected that, I have represented my clients in front of a magistrate judge, explaining to the judge, like, this is a child with a disability. These are the manifestations. We're involved. We're talking to the district. We've asked for evaluations. We're addressing this issue. So you can still talk about your child's disability and its manifestations to the judge and this other, the criminal court system. But the IDA doesn't stop the reporting or that whole process from occurring. If the LEA reports your child to law enforcement, your school district has to update the FBA and the positive behavior support plan. They have to make sure that your special education records are transmitted to this other system. They have to notify the other system, law enforcement, that your child is a child with a disability, and make sure that they have the information about your child's disability. So they can't just sit back and call law enforcement and say, well, good luck to you. They do have to take affirmative steps if they're going to contact law enforcement. Okay, what is the exception? So when can the school district immediately remove your child? Doesn't matter. We're not talking about the 10 consecutive days or the 15, or, when can the school district sweep in and say, we're going to expel your child, or you're changing your child's placement, you're going to an alternative setting? There are 3 instances, I call them the unforgivable acts. There are 3 very specific incidences where that could happen. If your child brings a weapon to school, if your child uses or has illegal drugs at the school property or controlled substances, and if your child causes serious bodily injury. And these are all defined and identified in the procedural safeguards notice. These are, reasons for automatic removal. You're removed immediately. If you carry
Tanya?
a weapon to school. Yes.
I'm sorry. Can you define serious bodily injury, just out of
Yes.
curiosity?
Yeah, the next slides are going to have it. So I'm going to get there in just a second. So the weapons, if you carry a weapon to school, or if you have a weapon in school, on school premises, or at a function under the jurisdiction of the school, like a prom or a dance, somewhere else, at a restaurant, that would be included. I've included here the definition of a weapon. They're actually going back to the US code to identify what a weapon is. But we're talking about a weapon, something very serious and significant, something that can be used, whether it's animate or inanimate. I was thinking snakes when I read that, but if it's used and readily capable of causing death or serious bodily injury, we're going to get to that in just a second. It has to be significant. There is a case where a kindergarten student had a pencil and hit the teacher with the pencil. And that teacher reported this 5-year-old, to the authorities, because they said, the student has used a weapon against the teacher. And, the courts held that a pencil is not a weapon. A pencil is not a weapon. It is not defined as a weapon. The student should not have been excluded from school, kind of expelled. We're talking about materials or substances that are readily capable of causing death or serious bodily injury. So the standards are very high. Knife blades. If your child brings a switch knife, those little pocket knives or something to school, sometimes they're in Boy Scouts and it's in their pocket or it's in their jacket or in their backpack, and they forget to take it out before they go to school. You measure the blade. The blade has to be more than 2.5 inches. So take out the blade and just measure the blade part. If it's less than 2.5 inches, it's not a weapon and does not qualify for immediate removal. And we're talking about immediate removals from school. Okay, illegal drugs or controlled substances. The student has to knowingly do these things. So, if someone slips it into the backpack and your child doesn't know, that doesn't qualify. It has to be knowing. Use illegal drugs or sells or solicits them, same thing, at school, on school premises, or at a school function governed by the school. Okay. I didn't list all the controlled substances. I put a link in my presentation. You can just click on it. It'll take you right to it. They're over 30 or 40 or 50. I didn't add them up, but they list the substances that are actually controlled substances. On there. Amphetamines are on there, morphine, stuff like that. It does not include substances that are used under the supervision of a doctor or a licensed professional, and or one that is legally possessed by you. It has to be illegal. Serious bodily injury is you have to inflict it, so it's not a threat. Yeah, you actually have to inflict it on someone, another person, again, while at school, on school premises, or at a function under the jurisdiction of the school. So what qualifies as a serious bodily injury? Again, we're talking about significant things. These are the 3 exclusions that, again, the district can immediately remove your child for. So we're looking at a substantial risk of death, extreme physical pain, a protracted and obvious disfigurement, or protracted loss or impairment of a function of, a body member, organ, or mental faculty. We're talking about significant things here. If your child was very frustrated and sometimes, they may flail out, teacher may try, a restraint or something, and your child harms a teacher or hits another student, or, something happens. The mere fact that the teacher goes to the emergency room doesn't qualify that as a serious bodily injury. So that's something to bear in mind. If your child is trying to be excluded and the district says, well, the teacher had to go to the emergency room, that in and of itself isn't enough. They have to show that there was one of these 4 things: substantial risk of death, extreme physical pain, a protracted, disfigurement, or loss or impairment of a function, of a body member, an organ, or mental faculty. So we're talking about extreme things. We're not talking about bruises, scratches, that kind of stuff. Okay, did I answer your question, Benita? Okay.
Yes, you did. Thank you so much.
We're
There always
almost
seems to be
there.
a gray area.
We're almost there, everyone. This is the last section: confidentiality and access to records. What records, when does a parent have access to records or a right to records, and what records are confidential? School districts or your school records must be kept confidential and cannot be released or disclosed. Period. There are certain exceptions, but that is the general overarching law and protection regarding confidentiality. Consent is required to release the records. And we're talking about information that is personally identifiable information. name, date of birth, address, anything that would personally identify your child's disability, the diagnosis, that type of stuff. That information, unless it's contained in educational records and the disclosures are authorized under FERPA without parental consent. So we're talking about, if your child takes the PSSA, and the PSSA, the agency needs all this information regarding a child, name, demographics, things like that. Those things are permissible. There are other releases that are not permissible under FERPA. If your child is attending a private school that's not in your school district cannot share information with the other school district. And we're talking about your child in a private school, but 2 districts are involved without your consent. So, okay. The consent is not required if there's an outside agency providing services to your students through the IEP. So sometimes school districts hire an outside agency to provide speech and language, OT, PT, that kind of stuff. You don't have to sign a consent. It's not required for that PT to get access to your child's IEP or other, information in the educational records, because they're providing services through, under the IEP. Officials participating agencies providing or paying for transition services also, they're considered kind of to fall under that same umbrella. And I put here after high school, it's not the transition from preschool to school age. We're talking about transition from school age to post-secondary. Okay, the parent must have access to the educational records. The school district is required to allow the parent to inspect and review the records that are collected, maintained, or used by the district. They have to comply with the request without unnecessary delay. Before any IEP meeting, if the parent says, I want to see the monitoring reports, I want to see my child's work, they have to comply with the request, for the parent to view those records. Before any due process hearing, the parent has a right to access the educational records. And they can't delay more than 45 days after you've made the request. So the LEA has to respond to your request. They can provide copies of records if you ask for them, or if going and looking at them is not something that's going to give you access to the records. You also have a right to send a representative to go inspect and review the records, and you can ask for a copy of them. The school district can charge you a fee unless the fee prevents you from being able to access them. Some copiers charge 25 cents a page. It adds up to a lot of money if you're talking about IEPs, evaluations, monitoring, progress monitoring reports. So if the school district is charging you a fee, and if they say, well, we're allowed to charge for this, know that if paying that fee makes, a difference between your ability to get those records or not, you're not required to pay the fee, because it's preventing you from accessing the records.
Question for you, and I apologize. How about if parent requests records to be sent electronically? Can there still be a charge for that?
If there is, I would, if there is an added, so this would be my response. If the school district has already scanned it and it's already in the system and everyone's throwing these records around by email, no, the records are already scanned. They're already in a format that can easily be transmitted to the parent. If the records are not already scanned and scanning them, if there's an additional cost to that, I would say that the district may be able to charge for that unless it prevents the parent from accessing those records. So I think with the, especially more recently with the electronic records, everything's getting scanned, especially during COVID. Everything was scanned and sent electronically. So I would question, any records in that time frame, a fee for any of that. Okay. If the records include information about other students, that's a violation of the other students' rights. Either those students' names have to be redacted, or the district is still required to give you the information about your child. So they have to work around that. They can't say, oh, sorry, we can't give you those records because there's another student's name on it. That's not a good excuse. They need to work around that. Okay. And the district has to keep a list of everyone who has requested a copy of the records, who requested it, and also where the records are maintained and who has access. Okay, I've gone through that information. All right, if you disagree with something in the record, you can ask for an amendment of the record. If you believe the information is inaccurate, misleading, or violates the privacy or other rights of your child. So, if your child is getting therapy for something that really isn't related to education, but it's just something separate, you can ask that be removed from the educational records, because of privacy or, impacts some other rights of your child. If you think the information especially is inaccurate or misleading, those are important circumstances. So you make a request to the school that they amend the records. The school district has some choices. So if the school district, within a reasonable period of time, they have to make a decision. If it says, nope, we're not going to change anything, they have to inform you in writing and advise you of your right to a hearing. So if you have a hearing, it has to be held within a reasonable period of time, reasonable advance notice of date, time, and the place, so that you have a chance to go. It has to be conducted by someone who does not have a direct interest in the outcome. It says someone, an official of the educational agency or institution could also do it, but I don't know how you get past the direct interest or outcome, kind of exception there. So, but it has to be, the hearing has to be conducted by someone who is impartial. The parents should have a full and fair opportunity to present evidence, documents, kind of state your position. You can be represented by someone of your own choice, including an attorney, but that's, at your own expense. You get a written decision within a reasonable time that needs to identify what the decision is based on and include a summary of the evidence and the reasons they reached the decision. If the decision is that the parent is accurate, that the information was misleading, inaccurate, or violated some other privacy right, then the school district has to correct the information in the documents. If the school district says, we don't think you've met this kind of burden of showing that it's inaccurate, misleading, or violates another privacy right, the parent could still add information to the child's record stating, I disagree with this. You can identify what you disagree with. You can state, why you think it's inaccurate, and you can ask that be included in your child's file. Now, your response to that, or your comment about that particular record, follows that record. So the school district is required to keep your response for the same period of time that they're keeping this record. And if they give that record, if they provide it to anyone else or release it to anyone, your response has to go with it. They're kind of married after you send that response in. Okay, everyone has to be trained. Everyone who has access to the records has to be trained about confidentiality and not sharing it without parental consent. They have to keep a list of people who have had access to it, or that they've shared it with under FERPA. destruction of records, the school district has to inform you when the records are going to be destroyed, and the information that will be destroyed. And some LEAs inform the parents when it will automatically be destroyed. So, for instance, the school district that my children went to has a policy, and they tell everyone who's about to graduate, if you want a full copy of your records, ask us for it, because after a certain period of time, they're gone. We're destroying them. So, and that's a notice you get, a written notice you get in the mail. There's some information that will be kept permanently in your child's records. So, 10 years later, if you need your child's grades, his transcripts, attendance records, things like that, these are the types of things that school districts can keep indefinitely. And that's it. I don't know if it's very late. It's 9:30. I'm happy to answer questions, Benita and Shane, and it's up to you guys. What would you like to do?
Oh, I have no problem leaving it open for questions. If any parents want to unmute and ask, I will tell you, Tanya, this was a really good, informative training.
Thank you.
Thank you. I really appreciate it. Does anyone have any questions that's still here?